Finally. So the first cause of action here is contracts clause. And the issue with contracts clause saying no state shall pass any law impairing the obligations of contracts. Okay, dipshits. Here's the problem with this. States are allowed to dictate how their subdivisions of the state operate and how they enter into contracts. Okay? This applies to private citizens. But by the way, we already do pass requirements as it relates to contracts. Contracts are impaired. So, by the way, the contract clause is not as fucking Gucci as they make it out to be. If I want a contract with somebody to bring in a kilo of that Mexican booger sugar, that Miami spice, if you will, I can't do that. It's illegal. Oh, but it impairs my obligation to contracts. No, that's not how it works. That's not how the contracts clause works. Those obligations have to be permissible and they have to be legal. If they're not legal obligations, it's not, they can't do it. And if it's a government, look, think about it like there are really only two types of governments. There's federal government and state government. Your county, your city, your local government, that actually is just a creature of the state. Your state determines what powers that county and city have. And they can do that if it's a state that has home rule. They can do that by saying, look, the state is reserving very few powers, and we're leaving most powers to the city. That's fine. But understand, if the state said, no, actually, let's say you live in Rhode Island, and Rhode Island said, we're going to do everything at the local level and county level, so we don't really need anything else, just the state. Because Rhode Island's small as shit. They could probably do that. That's perfectly permissible. There does not need to be cities and counties. Cities and counties are not a right. And certainly special districts are not a right. They are a privilege. There's a reason why Florida is the only state with these motherfuckers. The only state with expansive special districts like in Florida. You've got community development districts. You've got other sorts of special districts under 189. You've got these legislative districts. Way more in Florida than any other state. Tankrat says, how can you call Bay Lake a city when only 29 people live there and Lake Buena Vista is a city with 24 people? I agree. That's not a city. That's the people sitting in line at Chick-fil-A on 192 at any given point. By the way, I went to that Chick-fil-A so many times. Jesus Christ. My favorite Chick-fil-A. Very nice people. Right outside of Celebration. Yeah, here we go. Connecticut basically dissolved all county governments 20 years ago. No, many northern states don't have counties. Louisiana has parishes. So this argument is moot for that reason, but we'll go here. So the contracts clause prohibits local government entities from abrogating their contracts with private entities. So all of these cases they cite, note one thing about this. None of them are Florida cases. None of them. And all of them involve utility companies. Utility companies are quasi-governmental. It's not the same thing. Utility company law in Los Angeles and New Orleans, it is not the same as a development agreement between a government and a private developer that has statutory guidelines. Not the same thing. So this argument that they're just these open types of contracts which need to be that need to be interpreted as widely as possible. That's not how these things work. They're strictly confined. They can only do what they say they do in the statutes. So therefore, this one loses. I love how they try to increase the scrutiny. I love how they try to make it a moderate level of scrutiny. That's not going to work. This is actually, even if it was interpreted, even if the court did take this up, they're going to take it up under the lowest level of scrutiny because it's a government action. So that being said, that's the contract clause. That one will fail for that reason. Also, one thing, if they're arguing contracts clause, one thing they forget is consideration. You need consideration for a contract. If they're going to argue that they're pure contracts, well, there's no consideration. That violates a contract. Then they argue takings. Now, this is whack as hell, because with takings, and takings is eminent domain. So when you take something without paying just compensation. But the thing is, you have to actually try to take something of value and have real damages. There's no damage here until Disney goes to try to develop something and they're denied. No damage at all. And furthermore, these development rights, which are the only thing they argue about, these development rights are properly held by the district. They're the ones that are supposed to be dealing this out in a fair basis to the property owners. And they can deal them out based on how much money they contribute. That's fine. But you need to go and request it and be denied before you call it a taking. They have no actual damages here. And just the mere signing of a contract is not enough. By the way, there's no taking if the contract is void ab initio. If the restrictive covenants are void ab initio, which means it's as if they never existed. So the state case over here, the state case is going to wipe out the standing for both the first cause of action and the second cause of action. So it's going to nuke both of these. So let's continue to the third, due process. So this is one of their weakest arguments, that they didn't get due process. Are they not entitled to lobby? Are they not entitled to set up a super PAC? In fact, didn't these leftist rats say that they were going to only donate money to Democrats going forward and they were going to boycott Republicans? Wasn't that something they said? They're allowed to do that. That's totally fine. If they want to change the Florida legislature, good luck, but they can try. That's their right. Citizens United. And by the way, I don't like Citizens United, but it's there. So trying to argue they're deprived of process doesn't make sense. The legislature is your process. If you have a problem with what the legislature or the governor adopted, vote better, bro. And going for something as arbitrary and irrational is an almost impossible standard to hit. So for all of those legislative acts they're challenging, none of them are going to be overturned as arbitrary and capricious. Literally, there were points at which they said, yeah, we're going after this company. They don't do it. The only time they might go after it is back in the civil rights day. If they were saying, yeah, this law is meant to target black people and that's it, just black people. Yeah, then they're going to overturn that. But other than that, other than if you go and say that specific thing, they're not really going to overturn it as arbitrary and capricious. It's very difficult to do that. There's a reason why rational basis with bite really isn't a thing. There's a, rational basis, intermediate scrutiny, strict scrutiny. People try to make rational basis with bite into a thing. It's not really a thing. Government actions are really presumptively okay. So, also, when they say, there's no basis for repealing them, there is basis for repealing them. Not having notice, not having consideration, not mailing all the property owners notice, that is going to be enough. Even if one property owner didn't get it, that's enough. It's strict compliance. And then we got the two First Amendment claims. So they're different people. The First Amendment claims, I summarize these as Disney's hurt fifis. So first, they have hurt fifis regarding statements by the board members. So it's statements that the board members made that they are mad about. Actually, I'm sorry. No, I'm sorry. I'm incorrect. That DeSantis made that they were mad about that led to the board taking action. So they're not even really bringing up statements of the board itself. They're bringing up statements of DeSantis and saying because DeSantis said he was going to direct the board. But the board is supposed to be independent even of DeSantis. He appointed them, but that doesn't mean they have to do what he says. And they would have to certify as much. And by saying there's no rational basis to invalidate the contracts, there's plenty of basis. Like I said, no notice, no consideration, improperly adopted. All great reasons. Also, the fact that I brought up earlier that governments cannot delegate their governmental powers to private entities. Yeah, that's a big one under Florida law. It's a real big one. So obviously that would be another thing that would satisfy rational basis. And last but not least, another First Amendment violation. And this one is more directed towards the Reedy Creek bills, which dissolve Reedy Creek. So they're saying that the new board and its powers and composition is a problem. But the thing is, once again, that this is not a structure that's abnormal in Florida. In fact, it's a structure that exists in many other types of administrative districts for like ports and airports and stuff like that that are appointed. There's also other governor appointed districts. Also, whenever you have a multi-county district, it's automatically going to be appointed by the governor. So there you go. Nothing about their powers or composition is necessarily a threat. If the CFTOD has powers that are illegit, well, most of those powers were Reedy Creek's powers, so that would invalidate Reedy Creek. So once again, not really a good argument there. In saying, look, that the governor's mean tweets and his mean comments are cause for action and cause for a federal suit. How about those small business owners that were damaged by COVID? How about that? In California, could they all sue?